and in order to settle the hostage case, in order to release the hostages. Algeria was the mediator of the case between the US and Iran. Algiers Accord was declared, which tried to settle the dispute between two countries and also helped to release the hostage. And as for the Algiers Declaration, as the tribunal was established, there were claims against each other for the whatever happened as a victim of the hostage affair. The nationals of each countries, US and Iran, they filed case for reparation. There were over 4,000 claims were registered between in the span of 3 or 4 months. Some people who made claim against each other were the dual nationals, means the national of both countries, based on the virtue of their birth, or based on the virtue of their domicile, or based on the virtue of by descent. Jus sanguine or jus suel is both the Iran and US. What happened was, as the case was registered against each other by the dual nationals, claim tribunal in Hague, which was temporary tribunal, interpreted the law different, and the articles of the Algiers Declaration that came out in 1981 was not interpreted in a right way. Iran's claim was really based on the fact that those who made the claim against us, the Iran, were also the nationals of Iran. When it comes to the international dispute, the case of nationality and case of dual nationality, we have to set apart, because nationality and citizenship, the conflicting views between the two countries was, yes, Iran claimed at the time they made a claim against, they can only be the citizen of Iran, they cannot go against their own country. But there was a judiciary team made up of 9 judges, and out of 9, 3 judges were appointed by the Islamic country of Iran, and 3 were appointed by the USA, and the rest of 3 were theoretically they were neutral judges. So, but the decision based on the majority. However, those were appointed by the Islamic country of Iran, they actually opposed the interpretation of the article of the Algiers Declaration, and they said the verdict, and they made a decision against actually what is called is dissenting views. They registered dissenting views, and again, and in full hearing happened on the 10th and 11th of November 1983, the tribunal at Hague. Article 7, paragraph A1, national of Iran or the United States of the case means neutral person, because when the Algiers Declaration was written, it wasn't considered about the nationality, because they considered the Algiers Declaration as a whole instrument, whole tool to settle the dispute. Particularly the Algiers Declaration especially addressed or proposed to address the whole case or rebuild the diplomatic relation. So the Algiers Declaration was not really particularly made or declared for the purpose of nationality alone. So it was a kind of whole tool. The Article 7, paragraph 1 was considered when made the decision. US contents decision depends on the dominant and effective nationality of each national claimant. Yes, nationality also depends on the country of domicile, their interest, who at the time they made claim, where they are residing and where their interest in, and where their family ties with. It all depends, it all can be taken into consideration. So we may come up with different vision and different opinion. And however, one thing we can consider is, if the decision went against USA, and if the decision was in favor of the Iran, one thing would happen was there would be a state of impunity, because yes, they might have addressed the issue of Iran, of the nationality, but whatever happened during the hostage affairs, the diplomatic relation broke up, and there was a breach of state responsibility about the protection of diplomatic person, about the protection of, actually with relation to diplomatic protection and state responsibility, there so many things happened during the hostage affair case. There was a breach of international law with regards to diplomatic protection. So if the decision went against the US's claims, then there would be a state of impunity. The Notelbaum case we heard earlier, Notelbaum case of 1955, it was taken into consideration, means the judicial decision of the past and the customary law was also taken into consideration.